Everyone keeps repeating this one thing, that this new immigration law is either a total victory or a total disaster, but it's actually wrong. What was approved is neither a simple crackdown nor a generous expansion. It is something far more complex, far more targeted, and far more consequential than most headlines are admitting. And that misunderstanding is already causing people to make dangerous assumptions about their status, their timelines, and their future. Some immigrants will clearly benefit, others will quietly lose protections they assumed were permanent, and a large group in the middle will face new rules that look harmless on paper but become serious obstacles in real life. That's why this conversation matters right now, not months from now when rejection letters start arriving. Because once the law is in effect, there is no rewind button. What we're going to do in this video is slow everything down, strip away the noise, and walk through exactly who gains, who loses, and why the outcome is not what most people expect. The first thing you need to understand is how immigration laws are actually written and passed. When people hear immigration law approved, they often imagine one sweeping change that applies equally to everyone. That almost never happens. Modern immigration laws are built like layered filters. Each section targets a specific group, a specific behavior, or a specific administrative process. That means the impact is uneven by design. The winners and losers are built into the structure itself. This newly approved law follows that same pattern. On the surface, it promises efficiency, security, and fairness. Those words appear repeatedly in official summaries. But efficiency for the system often means more scrutiny for applicants. Security often means narrower discretion for officers. And fairness, as defined in legal language, does not always align with fairness as people experience it in their lives. Let's start with who clearly benefits, because there are beneficiaries, and ignoring them leads to an incomplete picture. Highly skilled immigrants with clean, well-documented histories stand to gain the most from this law. The new framework prioritizes applicants who fit neatly into predefined categories: stable employment records, consistent tax filings, verifiable education credentials, and no gaps that require explanation. For these individuals, processing times are expected to improve, and certain discretionary delays are reduced. In practical terms, that means fewer long periods of silence and fewer open-ended reviews. Employers who sponsor foreign workers also benefit under this system. The law introduces clearer compliance pathways for companies that follow the rules precisely. Businesses that maintain strong documentation and use approved hiring channels will experience fewer interruptions. This is especially true for industries that rely on specialized labor and have lobbied heavily for predictability rather than leniency. Predictability in this context is a form of privilege. Immediate family members of citizens in certain categories also see modest gains. The law tightens definitions but accelerates processing where eligibility is unquestionable. If your case is straightforward, with no previous denials, no overstays, and no inconsistencies, the system is designed to move you through faster than before. Now this is where many people stop listening because they assume the rest of the story must be equally positive. That assumption is where the danger lies. The biggest group that does not benefit from this law is not criminals or bad actors, despite how the discussion is often framed. The group most affected is people with complexity in their history. That includes long-term residents with old paperwork issues, families with mixed status members, applicants who changed categories multiple times, and individuals whose records tell a complicated story rather than a clean one. Under the new law, discretion is narrowed. Officers are given less flexibility to overlook technical inconsistencies, even when those inconsistencies were previously resolved informally. What used to be handled with requests for additional evidence may now result in outright denials. The logic behind this change is efficiency, but the real-world impact is unforgiving. Temporary visa holders face a particularly fragile situation. The law introduces stricter timelines for transitions between statuses. If you miss a filing window by days instead of months, the consequences escalate much faster than before. This affects students, temporary workers, and dependents who rely on precise timing to maintain lawful presence. One administrative delay, one misunderstanding, or one processing backlog can now trigger penalties that did not exist under the previous framework. Asylum seekers and humanitarian applicants are also facing a reshaped landscape. While the law does not eliminate these pathways, it raises evidentiary thresholds and narrows definitions in ways that are subtle but powerful. Claims that once qualified under broader interpretations may now fall short unless supported by extensive documentation that many applicants simply cannot obtain. This is not a denial of protection in name, but it functions as one in practice for many cases. Another group that quietly loses ground under this law is long-term undocumented residents who are hoping for administrative relief or expanded discretion. The new framework does not offer legalization, and it reduces the likelihood of deferred action being granted outside very narrow circumstances. That means people who have lived, worked, paid taxes, and raised families for years remain in limbo, with fewer safety valves than before. One of the most misunderstood aspects of this law is how it treats enforcement. Many assume approval of an immigration law automatically means mass enforcement actions. That is not what this law does. Instead, it sharpens enforcement precision. Rather than broad sweeps, it enhances data sharing, cross-checking, and automated flags. That means fewer visible actions, but more invisible consequences. Applications are now more likely to be cross-referenced against historical records, even those from many years ago. Small discrepancies that were once buried in old files can resurface. This does not mean everyone will be targeted, but it does mean the margin for error is smaller than ever. There is also a psychological effect that matters. When laws are framed as restoring order, they often create a chilling effect. People become afraid to apply, afraid to update information, afraid to ask questions. That fear leads to mistakes, missed deadlines, and avoidable denials. Ironically, the people who try to stay under the radar often end up worse off than those who seek clarity early. Now let's talk about the group that sits in the middle, because this is where the real uncertainty lives. Mixed status families are not explicitly targeted by this law, but they are deeply affected by it. When one family member's case becomes more fragile, the stability of the entire household is affected. Decisions about travel, employment, education, and healthcare become risk calculations. The law does not address these realities directly, but it amplifies them indirectly. Applicants who rely on legal gray areas are also in a precarious position. If your status depends on interpretations, extensions, or discretionary judgments, you are operating in a shrinking space. The law favors clarity over compassion, consistency over context. That may sound reasonable in theory, but in human terms, it leaves less room for individual circumstances. One of the most important things to understand is that immigration laws are not static events. Approval is only the beginning. Implementation is where the real impact unfolds. Agencies issue guidance, officers receive training, and internal priorities shift. The same law can feel very different 6 months after approval than it does on day one. That's why timing matters so much right now. Decisions made in the early phase of a new law often set precedents that last for years. The first wave of cases becomes the model for how the law is applied. If early interpretations are strict, they tend to stay strict. If they are flexible, flexibility may survive, but applicants have no control over that process unless they are prepared. Preparation, in this moment, does not mean panic. It means accuracy. It means understanding your own history in detail, not the version you tell casually, but the version that exists in official records. It means knowing where your case is clean and where it is vulnerable. It also means rejecting the false comfort of viral summaries. No headline can tell you how this law affects you personally. No short clip can replace a careful review of your status, your documents, and your timelines. The law creates winners and losers not by intention alone, but by interaction with individual circumstances. Another misconception that needs to be addressed is the idea that approval equals immediate effect. Many provisions have delayed implementation dates, phased rollouts, or depend on agency rulemaking. That creates a window of opportunity for some and a ticking clock for others. Missing that distinction can lead to irreversible mistakes. If there is one overarching truth about this law, it is this: neutrality is an illusion. The law does not treat everyone equally, even though it uses equal language. It rewards predictability and punishes complexity. It accelerates certainty and marginalizes ambiguity. For some people, this will feel like long overdue order. For others, it will feel like the ground shifting beneath their feet without warning. Both reactions are valid, but only one response is useful: informed action. That means asking hard questions now, not after a denial. It means reassessing assumptions you may have held for years. It means understanding that past approvals do not guarantee future ones under a new framework. And it means recognizing that silence from authorities is not reassurance. In immigration systems, silence often precedes enforcement or denial, not protection. So, who benefits? Those whose lives fit neatly into the boxes the law prefers. Who doesn't? Those whose stories are real, complicated, and human. The uncomfortable reality is that immigration law is less about morality and more about manageability. This new law makes that clearer than ever. It is not designed to judge worth, only to sort cases efficiently, and efficiency, by definition, leaves some people behind. As this law moves from approval to application, the gap between perception and reality will widen. People who thought they were safe may find themselves exposed. Others who assumed the worst may discover unexpected opportunities. But none of that will happen evenly, and none of it will happen without consequence. The most important thing you can do right now is not to react emotionally to approval headlines, but to respond strategically to the framework that now exists. Understand where you stand, understand how the rules have shifted, and understand that doing nothing is also a choice, often the most dangerous one. If this conversation helped clarify what's really happening beneath the surface of this newly approved immigration law, make sure you stay connected and informed. These rules are evolving, interpretations are forming, and the real impact is only beginning to show. The question now is not whether the law has passed, but whether you are prepared for how it applies to you.